My last video, I promised, for the hospital stuff, and this is something that's going to be very short. So this is going to be very short, and I want you to. This is going to be. You already had this information, but I want to touch on this. Be very aware of the Earl Warren Court in the 1960s. Like I said, for the AP test and for the EOC, Earl Warren as the Chief Justice was the second most important Supreme Court Chief Justice behind John Marshall, which John Marshall was the guy back in the 1800s, 18 teens, 20s, and so forth. We talked about a long time ago. So just like Marshall made a lot of important court cases that had long-lasting effect, so does the Warren Court. And this is something that the EOC and AP test want you to be familiar with as far as what court cases. And I remember I gave you a court case sheet. You can use that court case sheet to kind of guide your notes and so forth as far as which ones were what. On my test that I'm going to give you, I'm not going to have any like specific court case questions. Like I'll have a general court case question, but it will not be like a specific like what did this court case do? What did this court case do? Besides Brown v. Board, that's the only one that's like specific. Other than that, you need to be generally aware of these for when it comes time for the EOC and so on. So let me give you some overall ideas. All the Warren Court decisions are generally considered to be more liberal, that they expand the role of government. So you had Brown v. Board, which ended desegregation. That's the government getting involved in segregation policies of the South. But he's going to pass a series of important court cases in the 60s that you need to be just as aware of that are going to liberalize the government more. Okay, they're trying to address issues like criminal justice, states' political systems, definition of rights of individuals, all these different types of things. But SCOTUS becomes a big factor in the 60s, and like I said, go back and check your notes, or that Supreme Court sheet I gave you a long time ago. I think it's on Moodle. If I haven't posted in Moodle, then remind me, I'll give it to you later. But you should still have that from a long time ago. So I'm going to quickly run through these different court cases that you need to be aware of for the Warren Court. Now I'm going to go through them fast, so just do your best you can and go back and rewrite them later on. Gideon versus Wainwright in 63. That says that whenever you're arrested, you have the right to counsel, even if you can't afford one. So that gives you a lawyer provided by the government, which means that's more tax money paying for them. But that if you can't afford one, the government will provide you with an attorney. Escobedo versus Illinois says that whenever you're arrested, you have the right to remain silent. That you can wait to have a police officer present before you respond. So Escobedo versus Illinois says you have the right to remain silent. You don't have to talk until a lawyer is there present with you. Miranda versus Illinois says that you have to have your rights read to you whenever you're arrested and so forth. And you know the Miranda rights. You have the right to remain silent. Anything can be used against you in court of law. Blah blah blah. So that's part of that too. Yates versus U.S. This was a First Amendment protection of radical and revolutionary speech, unless it creates a clear and present danger. So Yates versus U.S. does a lot to try to protect your freedom of speech even more. Even if the government doesn't like it, as long as it's not creating a clear and present danger, it's okay. Engel versus Vitale says you cannot have religion in public school, meaning like you can't hold prayer, you can't teach the Bible in public school, those kind of things. Now you can have things like FCA or CH poll, as long as you don't force people to come. So like in the mornings when we have school prayer, you can't hold a school-wide prayer, and you're actually not supposed to have them like at football games and stuff, but we do. But all that behavior is illegal. Griswold versus Connecticut. A state cannot prohibit a person's use of contraceptives. It also gave the right to privacy. They also did some reapportionment in two court cases, Baker versus Carr, and then also one Reynolds versus Sims, basically saying that whenever you draw districts for Congress, like for the House of Representatives, like how our state has so many representatives, you can't just draw them however you want to. They have to be drawn in a fair fashion. So one of the big things that the Supreme Court does in the 60s is make reapportionment equal. So whenever they draw their districts, it has to represent the exact same amount of people for each district. So the idea is like one representative in Congress represents 100,000 people, so does the other one. They all represent the exact same amount of people, not these drastically different numbers. So all that's part of it. So Baker versus Carr and Reynolds versus Sims addresses those issues. So the Warren Court's decision to defend unpopular groups and freedoms of criminals provoked controversy at the time. Those decisions, though, have held a profound and pervasive revolution in interpretation of rights to this day. So they still have a lot of impact over the First Amendment and a lot of your other rights, too. So that's where we're going to stop these video series, and we'll resume all this on Wednesday. Good luck.